morning, everyone. Thanks so much for joining us for another episode of Will Work for Food. Today, we get to listen to not just our friend and colleague, but an expert on mediating ADA cases. So I know that most of you know who Jean is. She's one of the preeminent mediators on this particular practice specialty. But you can trust that what you're going to experience today with Jean providing this ADA program is going to be absolutely fantastic. So I don't want to keep people too long. I really want to just get to the good stuff. But the short bio for Jean is that she is based in Los Angeles. She is an attorney, mediator, and arbitrator. She mediates a wide variety of insurance, business, tort matters at pre-suit, trial, and appellate levels, as well as these federal ADA accessibility lawsuits. She is CIPP US certified, which is really important and a lot of fun, those cases. So she does all of the kinds of cases that are data breach and ransomware, cyber and privacy, those kinds of cases. She arbitrates insurance and business disputes as well. She's a AAA commercial arbitrator and mediator panelist. Prior to becoming a full-time mediator, Jean was a senior partner in a Los Angeles-based litigation firm representing corporations, professionals, nonprofits, individuals, and insurers in a broad range of matters at trial, in arbitration, and on appeal. She has mediated hundreds of cases over the years, and her legal experience has been diverse and international. She has a deep knowledge of the insurance industry, insurance policies, and all the various risks they insure against. So I don't want to keep you waiting, but if you need to know more about Jean, her practice, her specialties, or work with her one-on-one, please visit her website at lawleradr.com. And so I'm going to open it up to Jean. Before we do that, though, Jean, we need to talk about the purpose of Will Work for Food, in that you give your time and your experience to us. Nobody has to pay for these programs. Instead, we hope that if you are able, you will donate to either Jean's preferred food bank or to a food bank of your preference. So if your friends, your neighbors have a need at your local food bank, please donate what you can. And I have the new numbers about what we have raised thus far. Our industry has raised $314,383.95. Thank you all so much for your generosity. And so, Jean, will you do me a kindness, introduce your food bank, and then I will mute myself and the floor is yours.
Well, sounds good. Thank you, my friend. Hello, everyone. It's so great to see you this morning for me in Los Angeles. Whatever time of day it is for you, it's great to see you, whether it's evening, dinner, or whatever time. Yes. So today I would say for the food bank, the World Central Kitchen. If you're not familiar with it, I promise you, it's an amazing program. And they're everywhere in the world. I mean, they were there in Poland and the Ukraine with the Ukrainian refugees. They're here in the United States when there's flooding in certain parts of the country in the South. And I think that all of us worldwide on a global basis are well served by their work. So they are my suggested food bank for today. Thank you very much, Natalie. Okay, so are we ready to go? Laura's mine. All right. Well, hello. It's so nice to be here with all of you today. And some of you may have heard a presentation I gave on this in June for the mediators for the U.S. District Court here in Los Angeles. If you did, some of it will overlap. So mea culpa on that, but there are new developments as well. And otherwise, I look forward to moving ahead and seeing, where we all end up with this. First and foremost, let me say, as a mediator, I have mediated over 200 ADA cases here in California, both state and federal, beginning with federal. And then a lot of these got moved to state court for reasons that you'll discover why later on. Some of them just start in state court. New York and California are the primary places for these ADA cases. And just as a way of full disclosure, I did have a plaintiff attorney once ask me what was my background when I was in practice. Had I been on the plaintiff side of ADA cases or the defense side? And I said the closest I got to ADA cases when I was in practice was many years ago when there were insurance coverage issues under general liability policies of whether or not the insurance applied to ADA cases. So neither. I do not come from either a plaintiff or defense side. I come from the mediator's neutral, centralized, not even a side, central, and that's my perspective, and that's what I'm really going to talk about today, practicality. It's not going to be a lesson necessarily on, the law on ADA. It's going to be more on what's out there, what's happening, and then for the defense or the plaintiff attorneys, what they can take away from this, but then for the mediators. And you don't need to know the law mediators. Believe me, the attorneys will tell you what's what in their briefs. So that said, let's get going. So first and foremost, the American Disabilities Act was first enacted in 1991, and then it was amended in 2010, I believe it was. And there are several titles. Title III is what we're talking about today, and those are those laws and rules and regulations are relating to public accommodations. So your stores, offices, I suppose, just anywhere where the public, restaurants, where the public can go. And under Title III, a plaintiff must be disabled, first and foremost, within the meaning of the ADA. And then the defendant must be a private entity that either owns, leases, or operates a place of public accommodation. That's the phrase, public accommodation. And then 3, the plaintiff must have been denied public accommodation by the defendant because of his disability. So we have various words here that mean special things. And one of them, of course, is disabled, first and foremost, within the meaning of the ADA. That can be whole presentations in and of itself. So I leave you to, do any further research on that on your own. But let's go to number 2. The defendant must be a private entity that owns, leases, or operates a place of public accommodation. Landlords, tenants, owners, generally will be the landlords too, but they all are potential defendants and usually will be. So the fact that there is an agreement, a lease agreement between a landlord and a tenant, that maybe one is responsible for maintaining the premises in accord with the ADA laws here in America, does not mean that those folks are then free, so to speak, from any liability or exposure under the ADA. That's a contractual issue between the landlord and the tenant, for example. So that is important as a prerequisite here. And then the plaintiff has to have been denied public accommodation because of his disability. So that said, let me share my screen with just a little bit of background information here. First and foremost, are you all able to see this? It's a website, ada.gov. Yes, fingers, hands up. Okay, thumbs up. Okay, so this is the website. This particular is the beta version of the ada.gov website for all information related to the ADA, the laws and the regulations. And you can see there's all sorts of things here, both filing a complaint directly with the government as opposed to filing a lawsuit. enforcement, materials, the laws themselves, and then the various topics. They have an information line, and this is an excellent website, and it's much better than their old website. But you see here, disability rights are civil rights. From voting to parking, the ADA is a law that protects people with disabilities in many areas of public life. And just think about how it used to be, if you're old enough to remember walking down the street and the curbs when you came to an intersection did not have the cutouts. You had to step off the curb, and whether you were disabled, whether you were in a wheelchair, whether you had a walker, whether you had a baby stroller, pushing a stroller or any other thing, a wheelchair, very difficult to navigate. We can't really imagine that today because those cuts in the curbs are so, because they're everywhere, they're required. So the rest assured that the ADA has done so much good over the 30 plus years that it has been in effect. So that is a website that I would direct you to. And then let me share something else with you here. Let's see, let's stop that share for the moment. And then as another resource, okay, are you able to see this chart? Yes, okay, thank you. There is a blog that this law firm, Seyfarth Shaw, I never pronounce it out loud normally, so I don't know if I'm mispronouncing it, mea culpa, I apologize, but that they maintain. And it's a wonderful blog. It is called ADA Title III. And you can go to their website or just Google it, and you will be able to see it. But so they include updates on new case filings from around the country, and then statistical information. So I took a bit of the information and copied and pasted it here with full attribution to the law firm from whence it came. So here is the update. They do keep track of the Title III federal lawsuits that are filed. And so they've got this from 2017 to 2022. And you can see here that the filings are down a bit. They went way up in 2021 and then had dropped really with the COVID, I'm sure is why it dropped in 2020. And then you have to pick up and capture what you didn't have, what you missed out on in 2020, maybe for the 2021. So this is a mid-year 2022 from 2017. Now, let's see here. The next one here is California. You can see in California that they are down a bit, which is interesting because they had been on an upward trajectory, dramatic upward trajectory, and then have now dropped off. Part of this may be because of filings that are being done in the state court versus federal court, because again, these are only federal court lawsuit filings. Okay, then this here, just one second, let me try and center this. There we go. Okay, so these are for, the mid-year filings for the top 5 states. Again, Title III only. And so you've got New York right now this year being ahead of California, and then California, Florida, Texas, Pennsylvania. All right. And then here's the methodology that the firm uses. They take it from the federal court docketing system, PACER, and that also includes Title II. So they sort out the Title II from the Title III. And Title II is governmental, municipalities, things like that. This is their website. And then this is the name of what it's called, so that you can go there and check it all out yourself. You can also sign up to be on the receiving end of their emails. The website, accessibility lawsuits. these are increasing as well. And this is one of the charts that they had on their website. You can see that there has been a 14% increase in 2021 anyway, over the prior year of 2020. And the website cases, these are the numbers filed. The website ones, you can see they went up and down. And then here it's New York. The top 10 state for website cases. New York comes in way over everybody else. And again, it may be because of filings in state courts in California or even, some of the other states. So let's see what else there was there. Just one second. So I move this page down. And this was the comment actually from the lawyers who posted this. And they do say many plaintiffs prefer to file in state court where the law may be more favorable toward plaintiffs. And note, this is an older quote, but it says, especially when defendant is an online only business. Well, there's a new case decision in California. I think it came out within the last couple of weeks, and we'll get to it, that says online only businesses do not fall under the ADA. So we will see what happens there. It's a definitely an evolving area of the law. And then there's their methodology for the website cases. And so, with that, I will stop sharing my screen and get back to just talking with you. Those are some resources. There are many more out there, but those are two good resources for you. Now let's get down to it here. So an ADA case has been filed. The parties have been ordered to mediation probably. If not, they're going to mediation, but at the very least, generally they will be ordered to mediation. And so there are several things that are important to the mediation that are really not important otherwise to, sorry about that noise, if you can hear that. Anyway, to me, the components are really the fix. If there's a violation, what is it? Has it been fixed? What are they going to do about it? And then the money aspect of it. Under the federal ADA laws, there's entitlement to an injunctive relief, and to attorney fees. So there you go with the fix and the money. If you're in California, there's an added component called UNRRA damages, and that's a state law that has been ruled by the federal courts to be implicitly part of the ADA, if you will. If you have an ADA violation that's established as such, then you have an UNRRA violation as well. And UNRRA, UNRAUH is how you spell that if you want to Google it or look it up at all. That provides for a penalty. Generally, it's $4,000. Can be lower depending on certain circumstances, but generally it's a $4,000 per incident. And so, the going to the particular public accommodation, the gas station, the store, the restaurant, the whatever it might be, where the disabled person was not able to be accommodated, that would be one. And then the deterrence from going back, the plaintiff bar generally argues that that's a second, or there could be more than two. There could be three or four or whatever. But basically, we're talking about the fix. What can the parties agree upon? What is the time parameter? And then the money. And in these cases, oftentimes the defendants, they're small businesses, mom and pop types of businesses, which of course does not excuse any business from complying with the law that has been around for 30 plus years at this point. But they don't always have the money to make the payments for the settlement in one lump sum. Lots of times plaintiff firms will go ahead and do it in a payment plan or something like that. So let's get down to the core of it here. Questions to which a mediator should know answers in advance of mediation day, okay? First of all, what is or are the alleged violations that are claimed to be needing to be fixed? What is it? Is it a parking situation? Is it and then you get into all the nuances of that, the location of the parking spot, the markings, the slope of the parking spot, and then how you the access, the path of travel, how you would get inside, the signage. Are there directions regarding the path of travel? Who owns and controls the parking lot? It could be generally will be the landlord or the owner, not the tenant. But depending on the location, of course, it could be the tenant. Is it a store? Inside the store, the interiors, or restaurant for that matter, the counter heights, are those low enough? The sales counter, are they inaccessible? For example, it's argued lots of times by plaintiffs that it's the counter may be inaccessible due to merchandise on the counter. That doesn't always fly with the court, but that's an argument that I've seen many times in mediations. Are the aisles too narrow? Does the pay location where the people pay for their purchases, is that wheelchair accessible, number one? And then, does it have the ability to use the credit card machine, for example, there? The displays, there's, of course, signage issues, website purchases, things like that. The restrooms, the size of the room, the location and the height of the various things in the restroom. The sink, of course, needs to be able to have a wheelchair, be able to pull up under it. The way you would sit on the toilet, just the whole parameter. I mean, the mirror has to be no more than a certain height from the ground. All of these things. Restaurants, are the tables wheelchair accessible? Example, the height and the dimensions. 4 legs on those tables where a wheelchair could pull up, or do they have the center post where a wheelchair cannot pull up? Some center post tables are compliant, but not all are. And that generally can be a giveaway. For example, if it's just a center post table for 4 people or 2 people, it probably is not, but I'm not an expert in that. I just say that usually those end up going the way of needing to be changed to tables that have maybe 4 legs or such. Let's see, the height of the bar in the restaurant. Again, their restrooms. And do they have accessible tables in all areas where there are tables? If there's an outdoor patio, are there accessible tables there? Just like inside, are there accessible tables there? And the plaintiff lawyers will always tend to say that even if there are accessible tables, in one area of a restaurant, inside versus outside, for simplicity's sake, that's not good enough, that anyone should be able to come in and sit down at an outdoor table also and not have to ask for help and to bring a table out. The defense will say, we have these and we easily can move these tables. So, how the court would rule on that, that's not up to us. In a mediation, we're there to try and resolve the case. And so generally, those would be the talking points if that was the issue. And you'd go back and forth on that, and there would be an agreement of some sort if there was a settlement on what everyone would be doing regarding tables and other accessible elements. Hotels are an object of ADA suits, in particular websites allegedly not describing the accessibility features. There's a reservation rule, okay, for websites. And this is in addition to the physical barriers aspect of things. But for the reservation rule, let's see here. I think there is a case that talks about that. Just one second. Where did I have that? Well, never mind. I will just tell you about it. And basically what it says, and it's part of the ADA, is that the website or the hotel, and now it's the website generally, of course, but that it needs to be able to describe the ADA accessible facilities so that somebody who's making a reservation can know that it is, what it's supposed to be. And there are court cases. In fact, a recent one just came down recently here in California, and it talked about that it is enough to be able to say that ADA accessible, and then describe. There have to be descriptions. Let me see if I can find this. I have these screen shares ready to go, and then I changed a couple of things. So maybe it was on this one. Oh, yes. Here we go. You can see the screen, I hope. Let's see, was it this one? Here, yes, the reservation rules. So this particular case is out of the Northern District of California for the federal courts. And it is Whitaker versus Oci San Fran Llc. And this talks here about the reservation rule, requiring hotel reservation websites to share enough information online about their ADA accommodations so that people with disabilities can determine whether that hotel and its guest rooms meet their accessibility needs. I mean, that's it, plain and simple and very basic. Moving on down here, the court goes on to talk about what someone needs to be able to show to prevail under Title III of the ADA. And then it talks about how the hotel reservation system, so it's not just the website, it includes websites, and what this reservation rule requires. So in this particular case, let's see, they go on with more of the background in this course. Here's this defendant's website. It was Comfort Inns and Suites, and their website stated which rooms were ADA accessible and identified which ADA accessible features those rooms offered. And here's what the court said. In this case, a hotel is fully compliant with the current standards if they need only identify which of several acceptable alternative features the room provides, such as whether it has a shower or a bathtub, ideally. So in that situation, it was found that there was no violation because it offered the plaintiff the details he needed to assess whether or not the hotel or the guest room met his accessibility needs. Okay, and here's an example of this thing with UNRRA. And because the UNRRA Act is coextensive with the ADA, and this is from the Ninth Circuit, 2021, so then this plaintiff could not state a claim under the UNRRA Act either. So he was not able to prevail, but that's the reservation rule, okay? And then you do get, let's just take it right there to website. There are a lot of website cases, as we saw in those statistics. And which content guidelines, the WCAG guidelines, are compliant. Basically, at least the 2.0, and probably it will end up with, I think there's a 3.0 that's in process here or is in the works, but let's see, the website cases. So there was this new case that just came down, let's see, August 1st, that seems like yesterday. And this is the Appellate Court for California. This case came out of Los Angeles County. And there it talked about whether or not this particular website constituted a place of public accommodation. And what the court said here was, note all these little asterisk things here, under current law, so maybe the law changes, but we cannot read this phrase as including retail websites without any connection to a physical space. So if you are an online only business, this appellate court has said that the ADA does not apply to that. And then it goes on and it does explain why and the circumstances of what could be a place of accommodation, et cetera, et cetera. So I would leave you to check out this case. You could Google it, Alejandro Martinez versus Cotton Wash Inc., if you're interested in this. Now, this is an appellate decision. I don't know if it is going to be taken up to the California Supreme Court, but that would be its next stop if it did. As an appellate decision, it's binding on cases that are filed in that appellate district. So this is a second appellate district, which encompasses, for example, Los Angeles County. It's not binding on other appellate districts in California. So that's not to say that there can't be competing decisions on that issue, but that's where that stands right now. Then let's see. We already talked about the building owners. And so then the other thing that I would like to know, aside from what kind of a case is it that I'm dealing with as a mediator, and what are the issues, the status of the case, have there been any settlement discussions, has early mediation been ordered, is a summary judgment motion pending, and this is important, has supplemental jurisdiction been declined by the court for the UNRRA claims if you're in California. And that would be supplemental jurisdiction by the federal court. If you're in state court, it's there, and there's no getting around that. Federal court judges have been declining supplemental jurisdiction, and then in some cases maintaining, well, they haven't all been declining, but a lot of them have been declining. Then if it's still in federal court, then they handle the federal ADA aspect of it, the injunctive relief and the attorney fees. And then the plaintiff is left to refile if they want in state court for the UNRRA damages. And so this makes for a very interesting situation in mediation when you get to talking about settling, because the defendant will always say, oh, well, the UNRRA claims have been declined. Supplemental jurisdiction's been declined, so they're not in play. The plaintiff will say, well, we will just refile. We, of course, are going to want to settle the entire thing if we're here today to settle the case. And so then the defense may say, oh, they're not going to refile. Well, maybe they will, maybe they won't. You don't know. It's like a game of chicken, maybe who's going to go first on it. So you really do need to approach settling these ADA cases if you're in California with the UNRRA damages in mind, or you will not be able to settle them. Okay. And the courts are now replete with cases involving the UNRRA damages. Let me share my screen again here. There's, let's see, just yesterday, this came down. I mean, this is hot off the press. Vo versus Choi, the Ninth Circuit again, okay? And this held in a case, and it's important to know this is a default was entered against Choi, okay? So this was a default case, and the court declined. They wanted to decline to exercise supplemental jurisdiction. The court here, this is important, it ordered Vo, the plaintiff, to show cause why it should not decline it. They gave the plaintiff the opportunity to brief this on why they should not decline to exercise the supplemental jurisdiction. And so then Vo responded, and then after considering that, then the court declined to exercise supplemental jurisdiction. And they went through the circumstances, said there were exceptional circumstances, compelling reasons. There are cases that have said, and these are recent cases, that have said that if the court declines supplemental jurisdiction too close to trial, for example, then that's that's not good. They can't do that. Okay. But this particular case goes through the various elements if you are interested in this. Excuse me. Now, there was another one that came out in August. Let's see, the name of this case is Ho versus Russi or Rusi, maybe, Ninth Circuit. And here, the trial judge, federal court, of course, had declined to exercise supplemental jurisdiction of the state law claim for the Unrest Civil Rights Act. And the court held that the appellate court, the Ninth Circuit, held that the district court had erred in just merely declining the jurisdiction without providing the plaintiff either with a notice of its intent to dismiss or an opportunity to respond, and that was error because plaintiff was entitled to argue his claim prior to dismissal. So in this is August, right? What was the day of that? August 19th. And so this case comes down September 21st. But by the time these got to the Ninth Circuit, they'd already been handled in the underlying court. So here, though, this court, talking about the need to allow the plaintiff to do a prove up, so to speak, said that had been done. So that is why then, I suppose, maybe there would have been other reasons, but that's why in Vo, they went ahead and said the declination of supplemental jurisdiction was okay. So that's very important. Prior settlement demands, offers, when were they made? Lots of times there are initial demands and offers, but they're not recent. They may have been when the lawsuit first came in and somebody picked up the phone and called the plaintiff's office and said, "What are you talking about?" Maybe no lawyer was involved yet, that type of thing. But then it never went any further. Have the issues been fixed? That's critical. Are they in the process to be fixed? Is a fix even needed? Or is the issue incapable of being fixed? Is it readily achievable is a phrase. We've talked about the reservation rule, supplemental jurisdiction. Is it readily achievable for whatever the alleged violation might be to have that fixed? And I have seen a number of cases, for example, in old buildings, maybe where there's a step up directly from a sidewalk, a city sidewalk, and there's a step up that goes into the building. And there, the sidewalk does not belong to the store or the building. What do? Do they put a ramp out? Do they compromise and put a doorbell kind of thing with a notice, a phone number to call? There's all sorts of things that can be talked about during mediation to be able to accommodate what the issue is for that particular plaintiff. These plaintiffs have to speak on their own disability and their own issues, not the world at large. So someone who has sight or hearing issues, does not have standing then to try and deal with something with someone maybe in a wheelchair that is not their issue as well. And then does either party have a Casp inspector's report? A Casp is spelled C-A-S, and that's in all caps, and then a lowercase p as in Paul. A certified access specialist. California has these, maybe other states do as well. You can Google it, and it comes up with a page and a list of people who have been certified to serve as a Casp inspector. I have had a number of mediations where either lawyers who were not familiar with these cases, maybe this is a business client they've represented for many years, and now it suddenly has an ADA suit that is in front of them, or they're from out of state and not used to dealing with this. I always say, do you have a Casp report or do you have a Casp inspector? If not, ideally you get one. You do have to pay for the Casp inspector, and some people are trying to conserve money, but that's their decision to make. If you have a Casp inspector's report, usually it'll be the defense that has it. The plaintiff might have one as well. If it's early enough in the case to go to trial, they probably will have one, but the defense should get one as well. I mean, let the Casp, let a specialist take a look at the property, see what's compliant and see what's not. And then, I mean, this is the law of the land. It's been in effect for more than 30 years, and make sure the business property, whatever the facility is compliant. If it's not compliant, and again, there's a gray area. There are things that a plaintiff may say should be compliant that the defense or a Casp inspector says is compliant, or alternative ways of making it compliant. And, two Casp inspectors may not agree either. So you can have dueling experts, as in any type of case. So that is very important. If you do have a Casp report, there are, like under the California statutes, there are some, what would you call it? Like safety provisions that would apply to a defendant to help protect them against the ADA lawsuits, even if they turn out not to be compliant with something, if they have a Casp inspection and certification as such. So I would urge that, and, get to know, if you're the lawyer involved here, get to know the Casp report. And if you are the party not being represented by a lawyer, you can certainly go hire one yourself. And if you're the mediator, ask the question, is there a Casp report? And see what you find. Now, even if there is, they don't always share them. I had a mediation, I don't know, a week or two ago, where the defense did have a Casp report, but they'd not shared it yet with the plaintiff counsel. And of course, plaintiff counsel saying, well, give us your Casp report. Let's see what's what. So that's what you've got there. In terms of topics raised during the negotiation, defense, here are some responses, okay? For example, the defense may say, oh, the plaintiff is a serial plaintiff. The plaintiff has no standing. No proof the plaintiff actually visited the property or intends to return. Because under the law, the plaintiff, to have standing, has to, meet the disability requirements of the law, and then has to have visited the place and has had to encounter a barrier. And then they would argue that they're going to be deterred. So there are defenses that defendants will assert, saying, this particular plaintiff, they never visited. They just, they just maybe looked me up on Google Maps or whatever. It's amazing some of the things that people will say. Well, I can tell you in my experience with as many mediations as I've done, I promise you from a defense perspective, that is not going to settle a case. It doesn't matter if someone has filed hundreds of these cases. You may not be thrilled with that, or you may not be happy about it, but it is what it is. And they're entitled to file these lawsuits. And if you have non-compliant businesses, they need to become compliant. So either you are or you are not compliant, generally speaking. So I do not give any, don't even waste trying to argue to the mediator, oh, well, they're a serial plaintiff, a frequent filer, or whatever. The only way that it really comes into play is perhaps in California, why the idea of refiling in state court, the filing fee, if you filed more than a certain number of these lawsuits within a certain amount of time, is there's an extra, I think it's $1,000 that they have to pay for the filing fee. And keep in mind, though, from the defense, for the defendants, is the ADA, injunctive relief, and attorney fees. So if you do have a problem out there, at the location, and even in state court, you're found liable, fees and costs, well, that includes the extra filing fee that for refiling in state court. So don't bother that. That's not going to get the case settled. Just the mere fact of being a frequent plaintiff. The standing is something that is discussed regularly. Most plaintiffs have pictures of themselves at the particular location. So just because your camera doesn't show, your employees don't remember somebody coming in, or whatever, that doesn't mean that they were not there, that the plaintiff was not there. So I think you need to, unless you've got the proof, you need to anticipate that the plaintiff will have proof that they were there or that they would be returning to that particular property. The issues have been fixed would be a defense response. And we will file a motion to moot out this case because remember, injunctive relief means you have to have a case in controversy right then and there to get, something that needs to be protected. So a defense may say, we'll file a motion to moot out the case and get it dismissed because no injunctive order is no injunction is then able to be ordered. That said, the plaintiff could still file in state court for the UNRRA. That does carry traction with the plaintiff side of the equation if they fixed it. And fixing it is exactly what defendants need to do in general, whether without regard to settling the case. They need their properties to be compliant or they're in violation of the law maybe, and maybe then a next person coming along will file another lawsuit. So fixing is good. And as soon as possible. Under the California state law, fixing sooner than later means that you may have a lower UNRRA claim of damages. The defense I already talked about this, supplemental jurisdiction has been declined, so no 4,000 UNRRA. Well, just because the federal court declined, it doesn't mean a state court will, state court won't, they can't. So, again, you're playing the game of chicken. Will they refile or not? Any settlement does need to include something that would be a full and complete global release, including UNRRA statutory damages. A fix is not readily achievable. The defense will come up with that a lot, and it may very well be the case. And if it is, like any lawsuit, be prepared. Show why it isn't. Maybe have your Casp inspectors report, things like that. The website is compliant. Public restroom is not required. I hear that. Sometimes, they'll say the bathroom is for employees only. Well, maybe it needs a sign that says employees only. And as a policy, we don't let customers use the restroom. Things along those lines. Attorney fees are unreasonable. Well, at the end of the day, if you don't settle the case, a judge will decide whether they're unreasonable or not. And more attorney fees, will have been racked up. Plaintiff's responses to some of these that the defense will bring up. Plaintiff did visit the location and has pictures, or the plaintiff tried to access the website. The plaintiff does plan to return to the location. The plaintiff had a reason for being in that location. And even if they try to moot out the case, we'll refile in state court. Et cetera. And bottom line, the plaintiffs will say that, this is the law, there's a violation. If it's not fixed, tell me why it isn't a violation. And, my client, the lawyer will say my client has the right to bring these lawsuits and get these things fixed. It's definitely an area of the law, keeping the courts very busy, keeping mediators busy, and keeping the attorneys and the parties busy. So again, it's evolving. And especially, I think you're going to see some interesting developments with the website, not even the hotel reservation rule one, but the regular websites. There was a Domino's pizza case, and whether or not the Congress or the law gets changed to say that it does apply to the website aspect of it, does apply even under today's world to non-brick and mortar stores and businesses, things like that. So with that, I think I've covered a lot of territory. Hopefully I covered what you do. Oh, here's one thing I learned, actually, one more thing. It's a little tidbit, if you will. One mediation I had, the the plaintiff was using a screen reader, and the plaintiff counsel's office told me, you know, his screen reader does not, it cannot it cannot read the symbols in your Zoom, you know, password. Okay, he needs a password that only has numbers in it. And I don't know if letters would have worked as well. Maybe they would have. But I changed my automatic Zoom password link for people when they sign into mediations, so that it was all just numbers. I mean, it's still mixed up, but it's numbers. And so that's something that I had not known before. And you may want to keep that one in mind if you're mediating in these cases, or dealing with people that use the screen readers. So with that, open it up for questions. Let's see. Okay, we've got a lot here. The EEOC directives, this one just came in, that mediators must make accommodations to spaces, process, etc. Thoughts? I believe that's the case. And if you are mediating on the federal court panel, I think that's why a lot of people use the federal, the courthouse for the location. But most of these now are on Zoom, quite frankly. So, but if you are in person, yeah, it's a place of accommodations, I would assume. So I think that that's right. But check it yourself. I'm not practicing law right now and giving legal advice. Let's see. There we have the Reverend David Baca. Jean, is there any case law mandating all buildings must have automatic front doors, or at least doors with push button access? I don't know. Sorry, I'm here to get the cases settled, and I've not had that issue come up in a mediation, and I don't know the answer to that. I'm sure you can Google it though and find that out. Sorry, I can't help you. P. Taylor to everyone. Real money damages for invisible disability. Good case law. You know, disabilities they don't always show, obviously. So certainly my experience is California. If you meet the definition of disabled under the ADA and had an issue and, you know, would meet the various legal requirements, then yes, you can get the UNRRA. The UNRRA damages are built into the ADA just by implicitly built into it. So I think that is important to know, and positive for plaintiffs and defense alike to know. I don't know about any case law on that, but again, I'm sure you can Google it. And somebody put some resources in. Oh, okay. State courts, got that. Good case law. Title V. So look at the chat. Everybody's been great. Oh, Texas has certified access specialists as well. Great to know. Here's Michael Compion, speaking of yesterday, that Voe decision. Yeah, justified by exceptional circumstances. That's one of the categories and why they were able to decline supplemental jurisdiction. Let's see, anything else? Question for the speaker. Have you dealt with anyone alleging that a hotel room is inaccessible to the deaf hard of hearing? It's been a real issue for me for the last 30 years. Oh, I'm sorry to hear that for you. I have not had anyone claim that in any of my hotel mediations. So I'm sorry, I don't have anything on that one. And then you had regarding Martinez, there's a perspective, and that link is available to everyone. More links. Like I say, this is a hot topic. If anyone has any other questions, we've got a few more minutes. I want to raise your hand or speak up. I'd be happy to see what I can answer. And again, I'm not here to train you on the law of ADA, more on the settlement of ADA cases.
A question here from Joanne. Do you find when you mediate these cases, are you meeting with parties jointly, or you're doing separate meetings, caucus, or are you bringing them all a lot together so they they can discuss with you as a group?
Well, good question. Thank you. I always bring everybody in together to the main meet. And okay, we're talking Zoom, right? Or online. I've not had one of these be in person since March 11th of 2020. So back to the online. So I bring them all into the main room first to say hello to each other, to do introductions. I think it's important that everybody see each other, and that's in every mediation that I do, unless the lawyers have specifically asked not to do that. There may be some very sensitive, sexual harassment kind of cases or something where they wouldn't want to do that. But then I sometimes it depends on who it is. A lot of the lawyers, they know each other. They're up against each other all the time, the plaintiff side and the defense side. And sometimes they want to just talk like that, but generally I bring them to separate breakout rooms and establish first what the violation is and what's the status of the fix. Let's talk about the fix and then let's get into negotiations involving money. And then I will bring the lawyers together, certainly throughout as may be appropriate. And definitely at the end to work out how they're going to do a settlement agreement or a payment plan or whatever it might be. So that's how I do it.
Thank you.
You're welcome. Anyone else? All right. Well, it's wonderful to be here with you today. If any of you want to, mediation without lawyers. I have had some of these be pro pers, actually. You say better or worse? It depends if the person knows. It just depends, I guess. It's dependent on the person, whether it's better or worse. And maybe sometimes maybe they'll get a better deal if they don't have a lawyer. I don't know. That's hard to say, but pleading poverty from the defense side, that kind of thing. If they appear without a lawyer, generally the plaintiffs will all have lawyers, and it's very rare that the defendant does not have a lawyer. If you want to reach out to me personally, I'm happy to take your calls, your emails, or have a little Zoom with you or whatever at any time. These are cases that are fascinating, and however you feel about them, they're important cases. So thank you all so much, and best wishes to you all. Thank you for being here today, and thanks for any support to your local food bank or the World Central Kitchen. Bye-bye. Thanks so much.
Thank you very much.
Oh.